All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Thank you. Please be seated.
Thanks for moving my stuff. This too? It's good. I wouldn't want to drink out of Judge Portman's cup.
I know. This is the time set for oral argument in the matter of James Minato versus Charles Van Cott et al. Our cause number CV150159. Each side will have 20 minutes for oral argument. As you come forward, please identify yourself and your client. We have conferenced this matter. We've read the briefs. We have an idea of the issues coming forward. And with that in mind, Ms. Gillespie-Strub.
My name is Deanne Gillespie-Strub. I represent Mr. James Minato. Good morning, Your Honors. May it please the Court.
Can I request that you either be closer to the mic or speak up?
Yes.
That'd be good.
Should I repeat?
No, you don't have to tell us your name again.
Thank you. Your Honors, like the case that I just listened to, I think our good Judge Hanna was very concerned about public policy, and it caused him to be blind to the clear, well-pled facts that shows that this was a case where an attorney who has an obligation, who is an officer of the court, had knowledge. What is part of the record is that damaging email that Judge Porter found to be a farce on its face was received by Mother's Counsel on just before a trial was to begin. He'd been representing Mother since well before February of 11. This was received in August. He didn't attach that email to the motion filed under seal. That's relevant. That email was Exhibit 47 in the trial. Judge Portley looked at that email.
Judge Porter.
Oh, I'm so...
I didn't look at it. Trust me.
Pardon me. Pardon me, Judge Porter.
Counsel, if that email was not attached, why wouldn't Judge Porter have said, where's the email?
He took the word of counsel that there were allegations that were sensitive in nature that needed to be explored.
Your argument is, I take it, that by not attaching the email, counsel arguably or allegedly dressed up the allegations.
Oh, big time. Not only that, that Exhibit 47 has a really damning aspect in it. That email that was received from his client and forwarded promptly had redacted the subject line as it came from his client, but he forgot to erase the fingerprint when it went on. The dramatic email, LOL, was never supposed to be seen. It was redacted in the part that came from his client to him, but didn't get redacted as it got forwarded on.
When you say it's Exhibit 47, you mean in the family court, or do you
Judge,
mean here?
No, I mean in the family court. It's part of the record in the family court. Your Honors.
Let's back up for a second. I just want to make sure we're on the same page as to what Judge Hanna was looking at. He was looking at a complaint with no attachments, right? A motion,
That's correct.
a response,
That's correct.
and a reply.
That's correct.
But, so we don't have the email, do we, in our record, or the
email.
Or in fact, even the motion to continue in our record.
Yes, the motion to continue is in your record, Your Honor. It was attached to the pleading and the answering brief. And counsel for...
That's not in the trial court record.
No, but counsel indicates that the court can take judicial notice of what was in the trial court record, and he gives the law supporting that, and that's why he brings that forward.
We could probably do that.
Sure. And Your Honors, what is in the pleading, Judge Porter made the finding that that email was the most damning. There was egregious, outrageous conduct. This matter, which could have been concluded in August 12, went another 18 months to the tune of $100,000 worth of litigation. False allegations of sexual abuse should not be taken lightly. I understand there's something that the court needs to address. But there is a bright red line that apparently needs to be clarified by this court. Judge Hanna, who is a very good, thoughtful judge, hesitated. He sees the good that attorneys do when they're caught up in the often high conflict matters in family law. But when an attorney has knowledge, you've crossed a line, and your role as an advocate no longer protects you.
Did your complaint allege that the lawyer knew, as opposed to the more general allegation of should have known?
It said should have known, but when you take all of the allegations together, the law provides that a very reasonable inference is he knew. Judge Porter had found that that email was damning, and the email was received by the attorney. The attorney did not attach it, and this is a de novo review. The attorney did not attach it to this. Also, it's important, what was before Judge Hanna, this wasn't an arm-length representation of Kimberly Wheeler. The attorney was the good friend, that's in the complaint, was the good friend of her intimate boyfriend, Mr. Zach. So he begins to represent Miss Wheeler, and then the night before a proceeding occurs, he gets a very uncomfortable circumstance. He had an obligation to deal with it properly. He made a choice. He tried to veil it with a, gee, she doesn't know whether it's true or not true. She knew it was not true by the caption of that email, and he knew it was not true by the caption of that email. Judge Porter's finding that she knew it was not true by the caption of that email goes to the attorney, too. Judge Porter made a finding that that caption of that email showed it was a farce. That's a judicial finding. The email was received by the attorney. The fact that the attorney did not attach that email to his motion to continue the trial is an evidence that he knew. The fact that the damning words were redacted before it was forwarded on, but there was an error of not redacting it the second time, shows that attorney knew. We as officers of the court have special rights. In the family law court, we have limited access to the courts because they're so crowded. When you spend $100,000 worth of litigation and you drag a father and children through false allegations, there have to be consequences. And Ms. Wheeler could not have done this without the skills of what should be a very capable attorney. This could not have gone on this long without the advocacy, and the court found that her conduct throughout the proceedings was egregious, was outrageous. Her attorney would know that. One of the causes of actions is wrongful institution of civil proceedings, and in there, one of the elements says there's a continuation. Maybe you don't know in the beginning, but at some point you know. By the time 18 months we get to trial, the court finds that her conduct throughout the whole course of this is egregious, and it starts with a label that this allegation is a farce. We just celebrated the 800th year of Magna Carta, and that stands for the fact that not even kings are above the law. The rule of law applies to everybody, and we as advocates, when we cross that bright red line and we knowingly do things that will harm others, clog the system for people who could be using that judge that day, those psychologists that got involved in this, we have a responsibility. And we should not be shielded from the full weight of the law, from the civil actions that arise from such conduct.
If there's any potential that this kind of sexual abuse whatever the specific allegations were, what was going on, then the lawyer has the obligation to try to get a continuance and get it investigated, right?
I agree, Your Honor. However, he ought to give full information to the court. And if he gave that email in its entirety to Judge Porter, it may be that Judge Porter would nip it in the bud and say, is this really real? And it could have been addressed without 18 months of litigations and all the garbage that went along with it.
Counsel, which is the stronger claim, the abusive process or wrongful institution of civil proceedings, as you view those?
I don't have an opinion on that, Your Honor. Perhaps the wrongful institution of civil proceedings, because there's that continuation, and at some point, if you didn't know in the beginning, you got to know soon. When you sit next to a client that is so incredible in a deposition, that incurs the court's concern to the point where there's $100,000 in attorney's fees judgment awarded. When you sit by and watch the farce continue to unfold, at some point, you, as an officer of the court, have an obligation to say no more. No more. You don't continue to be the engine, the essential component of using our legal system improperly that causes damage. Ms. Wheeler, again, could not have racked this havoc without the assistance of a skillful attorney. It wouldn't have gone on 18 months. It wouldn't have lasted this long. And to say to the court in that initial pleading, Judge, I just learned we've got this sexual abuse, and she doesn't know whether it's true or not. And you don't tell the court when you're filing that and signing it, but she sent me an email with the caption of the dramatic letter LOL. Judge Porter found she knew. That email was sent to her attorney, who knew. I don't think attorneys that work in this area start out intending to make a muck of things. But when you get too close and you lose your objectivity, if you're a good buddy of her boyfriend, and our pleadings alleged that she and her boyfriend talked about the fact that they really wanted to cause him trouble. When you lose your perspective, there's a problem. And perhaps if there had been a very clear opinion that in family law, the role of an advocate, if you cross over that bright red line of knowingly perpetuating whether it's false allegations of sexual abuse or other false allegations, you have crossed the line. Perhaps Mother's counsel would have paused at that time when he needed to make a decision and not only simply veiled it and massaged it through the court, but perhaps he would have said, I can't do this. I won't do this. Or given it to the court and said, Judge, the email that I got, the notice that I got says the dramatic letter LOL. So let's deal it within the full context of what it is. Judge Porter didn't have that opportunity 18 months before he finally made a ruling on this case. He wasn't given that opportunity by the person who came into possession of the information that started this travesty. Our society provides some of the harshest penalties for people that abuse children. And the damage that can be done for false allegations of child abuse are comparable to the damage that's done by the actual thing. And you do not cavalierly push that very sensitive and important issue through without the full information to the tribunal.
Do you want to address the amendment issue?
Yes, Judge. I believe that our rules, first of all, the court has three. I believe our rules under federal law, our rule compares the sua sponte situation. I think if Judge Hanna had any reservations, he should have given us the opportunity to amend. However, the pleadings we have are sufficient. The court has three options. find in your de novo review that our pleadings are sufficient. Agree with Judge Hanna, which we don't think is the right decision. Or in conformance with the clarification of the law that there is a bright red line, and when counsel crosses that, they stand with full exposure for all the liability that the law provides any other individual, and allow us to amend the pleading to conform with the directives that you give and clarify. Thank you. I'd like to reserve some time.
Thank you.
May it please the court, my name is Tony Vitagliano, and I'm here today on behalf of Charles Van Cott and the Van Cott appellees. Judge Hanna properly dismissed father's claims against Van Cott's because, as a matter of law, considering all the reasonable interpretation of the well-pled facts, father's not entitled to relief under any reasonable interpretation of those facts, subject to proof. You've heard one-sided discussion of the procedures before the family court. That's why, as part of the appendix, we included the family court opinion. It sets forth that both sides were taking liberties with their conduct before the family court. The judge admonishes both sides for their activities. And as you see in family court oftentimes, it is a very emotional setting, and people do tend to act sometimes inappropriate, and there's no question mother's activities at depositions were inappropriate, but that doesn't alter why we're here today and doesn't influence why we're here today.
What do you think? What do you think we are here today for? Is it because the judge didn't feel the allegations were sufficient in the complaint in this case?
Yes, Your Honor. I believe it's Judge Hanna was clear that, and I believe correct, that merely because an email has a ray line that says LOL and attached to it is a letter not from the author of the email with the LOL in it. In other words, the LOL was in mother's email. She attaches another email from Rosario and a letter from Rosario, which includes alleged allegations by a son. And the mother says, I don't know if this is true. I have no knowledge of these allegations. That's the representation Mr. Van Cott gets the day before the hearing. Well, he asks mother, do you have any knowledge? She says, no, I have no knowledge regarding these allegations. The fact that her ray line says LOL, as discussed in our brief, can mean hundreds of things. And there's so much, dare I say, hate between mother and father that you could see her even using that as saying, watch this, now we got this. Not saying she believes it's true, but saying, let him, whatever. So it's a big jump to say, one, that LOL meant she knew it was true, an even bigger jump to say Mr. Van Cott should have known it was true because she used the LOL.
I'm assuming that you probably disagree with Judge Porter's conclusions, but let me get us, if I can, to the sufficiency of the complaint here. Why isn't this complaint sufficient to allege these torts?
As you know, for the various elements of the claims she's making, whether it's malice for one claim or whether it's the improper purpose with scienter for other claims, there has to be some indication of actual knowledge. And
Actual knowledge would probably suffice for most, if not all four, of the torts.
well, Your Honor, I think to reach some of the elements as set forward in the brief of each of the claims, there has to be a certain amount of scienter on the part of an attorney doing what an attorney does for a client. I think we've all seen the new attempt to recover litigation fees by claims against attorneys on the other side. I've been in front of this court myself 3 or 4 times in the last 2 months on abusive process type claims against attorneys. It is the new threshold way of trying to recover when you don't, when you have attorney's fees.
So in family court context or more broadly?
Pardon?
Family court context or more broadly?
More broadly, in commercial litigation, in criminal litigation. Luckily, we have protections there with post-conviction requirements, and now with family court. And in all those levels, the courts make clear that it's a special level of scienter you need under all these claims when you're going after an attorney, doing what an attorney normally does for a client in that situation. That's what was done here. Mr. Van Cott gets that the night before. His client tells him she has no knowledge of the allegations. Regardless of the ray line, she tells him she has no knowledge. So the ray line's irrelevant as far as if she truly has no knowledge. The fact that she says LOL in the ray line just indicates some emotion she has regarding the email. So it doesn't provide any type of knowledge to Mr. Van Cott. All he knows is now he's got these allegations. The statutes are very clear in Arizona that child care, allegations of abuse of child care under 25403 at SEC take precedence.
Understood. If I could
Sure.
get you to help me in regard to the complaint, is it your position that the complaint is insufficient because it doesn't allege that Mr. Van Cott knew that the allegations were false?
The complaint makes 2 allegations, and the complaint could not allege that he knew based on what she knows. But the complaint as it sits today, with the allegations she made, the father's made, clearly don't support the elements of the claims. And when an appellate court can avoid a case that's going to get dismissed, it should uphold the motion to dismiss. So I do agree, Your Honor, that the complaint as it sits today does not have allegations that can get by a 12b6 motion, and I would argue based on what they allege, what they know, it could never, because the mother tells my client, I have no knowledge of this, and she tells him that the day before, and he files this under seal. I mean, he's trying to use the most.
You agree it was just the motion, right?
I'm sorry?
It was only the motion to continue with no exhibits. Do you agree with that? Do you agree with counsel? Yeah, it was only the motion. There was no email, there was no letter attached to the motion to continue. Do you agree with that assertion? That
I think that is correct, yes.
Okay.
But he takes the opportunity to tell the court, hey, this is what I just received, and she says she doesn't know if it's true or not.
But counsel, what about the problem? What about the concern I have here is that at some point, doesn't it become obvious that these allegations are no longer true? I mean, if it's truly an 18-month period, and isn't that the theory behind wrongful institution of civil proceedings? At some point, a lawyer begins to wonder if those positions are sustainable once taken, maybe in the heat of the moment, and when there's maybe there was good grounds in the beginning, but at some point, can't that change?
Well, of course, Your Honor, it can change, but it doesn't here. The animosity between the two parties is constant throughout. Both parties are
I
doing.
think we could see that. I mean,
Right,
but, yeah.
right. That's clear as day. The son does not then testify. He said he would testify. He does not testify. And if he did, and as we know, with child abuse issues, that happens all the time. That for whatever reason, someone may not testify. So just because the animosity continues on both sides doesn't mean that the attorney has any reason to believe that the allegations in this letter are anything but truthful.
So he had Mr. Van Cott believed that they were
He does.
truthful all the way up until the judge's
To this
ruling.
day, he does.
To this day.
To this day, he does. And
Did he testify?
did he testify?
Yeah, there's no affidavit or.
Well, this is a motion to dismiss.
I mean, no. You're going to based upon what he.
Well, you asked me a
told you.
question
I mean,
on-
that's not in the record, correct?
No, I don't believe that's in the record. You're correct. But, so there's nothing, when you get to wrongful institution of civil process, there's no interpretations of the fact that make this something that a reasonable, prudent lawyer wouldn't do, filing the motion to continue. He doesn't say that the allegations are true. He says the allegations, we don't know if they're true. All he does is file a motion to continue. And the court has the ability to investigate. And the court does, in fact, assign a counselor to talk to the boys and does hold a hearing and comes to that conclusion, which, of course, is the role of the family court. Once counsel is presented with this allegation and in knowledge that his client says she has no knowledge of it, then he must bring it forward to the court. And, of course, if he learns something along the way that changes that, as true for the other side, then you file whatever you need to file. But that doesn't happen.
Do you have the complaint before you? Do you have
I
actual
do.
complaint?
I do, Your Honor.
I'd like you to, turning back again to follow up on Judge Gemmel's questioning, I'd like to drill down a little bit deeper on the sufficiency of the complaint. I'm looking at paragraphs 41 and 49 in particular, where both seem to specifically allege falsity. I mean, first paragraph, I'll quote paragraph 41, it says, defendants did so knowing that their claims and use of judicial process was false.
Well,
And then similarly, under 49 says that the defendants wrongfully prosecuted and continued proceedings in the family court matter seeking relief based allegations that defense knew to be false and untrue.
Right, and those are, in paragraph 25, is the allegation that,
Yeah, but I mean, I think.
and that flows from that. They're saying that
Don't we
he
look
should
at
have
the
known.
complaint as a whole?
Yes, you do, Your
I
Honor.
mean, well, how do we look at these two assertions here, 41 and 49, that say we're asserting, or they're alleging that the defendants knew that their claims were false.
Because, Your Honor, the Supreme Court has held that a court is not allowed to speculate as to hypothetical facts and only look at the well-pled facts and all reasonable interpretations of those facts. That means you do not accept as true allegations consisting of conclusions of law, inferences not necessarily implied by well-pled facts, unreasonable inferences, or unsupported conclusion from such facts, or legal conclusions alleged as facts. That's Jeter 211, Arizona, at paragraph 4. That's what's going on here. And that's in our briefs, Your Honor. And and again, the Rule 8 quote is from Cullen, 218 Arizona, paragraph 14. That's what's going on here, Your Honor. They're taking the mere fact of the LOL in the heading and saying from that they want to extrapolate knowledge sufficient to support their claims. And that's why the court on a Rule 12b-6 can say, you know what, under Arizona law, that's not enough.
Well, let me jump back in here. I think I heard you just describe your belief that the trial judge in this case considered the significance of the LOL subject line.
I'm sorry, Your Honor, I missed
I think I just heard you say that the trial judge in this case considered the significance of the LOL subject line.
Judge Hanna?
Yes.
He viewed that as insufficient evidence to support their claims. And as you know...
But I'm a little confused about whether the judge is really supposed to be weighing the evidence or considering the content of the allegations at this point. We're at the notice stage.
Right, Your Honor.
We're at the 12b-6 stage.
Correct. And he doesn't weigh, and I correct myself if I misstated, what Judge Hanna says is based on the allegations and the reasonable inferences from those allegations under Cullen, there's insufficient facts and allegations to support the claims going forward under Rule 12b-6.
Because what? Because they don't allege, or they don't allege sufficiently that Mr. Van Cott knew?
That's what...
Or is there something else besides
well, the court rules, as you say, that the allegations of knowledge are insufficient to show the required scienter, malice, etc., elements needed, mental state elements needed for those claims. So he's saying the allegations are insufficient to support those mental state elements of malice, probable cause, etc. And in fact...
Well, hypothetically, if we were to place you in Ms. Strube's position and you were alleging the facts on behalf of Mr. Manata, what else would be needed in the complaint to get past the 12b-6 hurdle?
If...
Hypothetically.
Right. I believe, Your Honor, if there was evidence...
No, just notice.
Okay, I'm saying if plaintiff had reason to believe and a basis to get by Rule 11, that in fact mother had told Mr. Van Cott that these aren't true, or something to that effect.
With the allegation then that after the lawyer received the email and forwarded, he removed the LOL, would that be sufficient to get past the 12b-6, but maybe not summary judgment?
I would argue no, Your Honor. I mean, I can understand why that might be deleted because it's irrelevant. She says she has no knowledge, and it's communication from a client. So I could see how that would get, removed. She says, I have no knowledge. So whatever she says in that rail line is irrelevant. She could say, I hope he burns in hell. She can say, it's just, at that point to the counselor, it's irrelevant. He's got to now deal with an accusation of child abuse that the family court needs to address, and it's the next day. So he files a motion to continue under seal saying, Your Honor, we just received this. We think we should continue it, and we think the court should investigate it. And Judge Hanna answers the questions that, of course, he does what any domestic attorney would do. As far as the amendment issues, Your Honor, I think our briefing of that is straightforward. The allegation that father's failure to file a motion to amend or a Rule 59 or a Rule 60 motion is somehow the fault of the trial court is outrageous. And in fact, the cases are clear. Even father's cases are clear. Father raised two cases in his reply, and those two cases are the Carolina casualty case, in which the plaintiff had filed a motion to amend the judgment under Rule 59 and submitted a proposed amended complaint as part of the motion. And even more on point is father's Chinatown neighborhood case, 749 F. 3rd at 1144 Note 8 in accompanying text, where the Ninth Circuit found no abuse of discretion for the court not to sua sponte grant leave to amend, noting, quote, it is even more difficult to perceive an abuse of discretion when the plaintiffs never sought leave to amend below, close quote. My time's up, unless there's more questions.
No, thank you.
Thank you, Your Honor.
Thank you.
I heard counsel say that somehow this is being brought to collect fees. There was a $100,000 judgment against mother for fees. Judge Porter didn't have the ability, it wasn't his jurisdiction, nor was it pled before him, to account for the other damages, the horrible damages that spill from false allegations of sexual abuse. He couldn't have remedied that in that forum. And that's why the civil suit was brought. There are all kinds of ugly damages. You know, when the testimony in the depositions indicated that mother's son told her, she claimed her son told her the same night she received that email from the son's girlfriend. And we alleged that there was a big conspiracy with her son, his girlfriend, and her. That's why you put the dramatic letter LOL. And in the motion to continue, it doesn't say, I got an email from the son's girlfriend. It just says, I got information.
I feel a desire from the comments of each side here to delve into all of this detail in the family court action, but I think
I agree,
that our
Judge.
task is limited
Agreed.
to looking at the sufficiency of the complaint to state a claim.
Your Honor,
Or
thank
to
you for
state-
bringing
to
us
state-
back
to
to
state
the
full
purpose
claim.
for which we're here. You're right. And what we told, what we informed Judge Hanna in our response to the motion to dismiss, the very first sentence was, motions to dismiss are not favored because they test the legal sufficiency of the complaint without the benefit of fully developed factual record. That's what we said right out to Judge Hanna. And then we went on to explain to him why the pleading was sufficient under the law. I understand.
What would, excuse me for interrupting, but let me ask, please.
Sure, Judge.
What would you allege differently if you were given another opportunity to allege?
You know, in hindsight, I would probably attach that email. I would probably attach it is only a notice pleading, and I put them on notice, but if it was necessary, I would go through the parade of horribles. It was like arranging deck chairs on the Titanic. This allegation of sexual abuse was sinking from the beginning. The ex parte communication with Dr. Pico, Blaze being shifted out of town, his refusing to take a polygraph. Brittany Rosario refused to show up for a deposition, and it seemed that was orchestrated and helped by Mother's counsel. And then she refused to honor a subpoena to come to court. There was all kinds of shenanigans going on in this. And a front row seat was Mother's counsel. That relationship that we alleged in our complaint, that he was a good friend of Mother's intimate boyfriend, I think impacted the judgment. And at a pivotal time in that representation, after he'd been representing his good friend's girlfriend, when she came up with this junk that should have been trashed, he used his skills to perpetuate it. I was reminded overnight of a lesson I learned when I was in law school. I helped do some research for a very respectable attorney who was a Supreme Court Justice in Utah and the Dean of Chicago Law School. In the Mercer Law Review, 1984 fall, there's a concept, rights and responsibilities of attorneys. We, as members of the bar and officers of the court, do not get a free pass to ignore things that we know are wrong just because we're an advocate. We can't. It is important to put up a warning sign. I'm hopeful that there will be clarification to the members of the family law bench. Rather than opening the floodgates, we can help shut some of the poison that's going on that's wasting judicial resources and harming families. Attorneys need to clearly know that if they cross that red line of knowing, their role as an advocate has been breached. Any other questions?
Apparently not. Thank you very much.
Thank you.
Appreciate the argument of counsel. We will take this matter under advisement and issue a written ruling in due course. Until then, we stand adjourned.